the communications discussions page?
Yeah, I looked at the announcements page, so maybe I'm just in the wrong spot to find what
Look
was
at
supposed to be.
discussion 4, the one with Hustler.
What are you looking for? Good
I'm
morning.
just trying to figure out and make sure I didn't miss anything, any of the readings, because some of it's on the announcement page, but some of it's in the syllabus, but some of it's over in the discussion board, and
True. Yeah. Well,
it's
there
kind of
really aren't. I don't think you should find. I don't think you need to look for readings on the discussion board unless I'm forgetting something. But
there's
um,
Discussion
so
number 4
yeah,
is what I.
I just
Discussion number
noticed
4 and
one
5 is what I did.
I just noticed one that's not on the announcements
so
now
what
list.
we're doing today is in a in our getting ready for the test one. I'm not 100% sure how much I told you about what we were going to be doing today. Um, so we're going to do the New York Times versus Sullivan libel case, um, the and Hustler, as one of you was just referring to the Hustler case
Yep.
that follows, and we'll also get over we'll get into there's a case that I don't well I'm not 100% sure if it's in the textbook in the case book, but I have a link on the syllabus page. Milkovich, which is about the how defamation in opinion. Uh,
It's on the discussion and on syllabus, and I believe it's on the study.
okay, good. And and then we're going to get on move on to school speech, Tinker, Hazelwood versus Kohlmeyer, etc. So before we get
You
started, does
you said
anyone uh, have have something in the news they want to talk about or present for extra credit?
hmm,
There's um, I guess the main thing in the news I saw was the President-elect Trump's nomination of Matt Gaetz to be Attorney General. That's going to be you'll be hearing a lot about that as time moves forward. A lot of he has a lot of critics in both the Republican and the Democratic Party. So that might be the case in which Trump's um, Trump may try to insist upon the Senate allowing him to make a so-called recess appointment, which allows a person to take their office without before any confirmation by the Senate. Um, so we'll see how that plays out. Gates is very controversial because he was sort of the person within the Republican Party who forced Kevin McCarthy, the Republican House Speaker, of his out of office, and then McCarthy tried to run a Republican tried to fund a Republican candidate against him in the 2024 primary in Florida, and that was very unsuccessful. Gates uh, got through. Anything else you want to talk about in the news, or we'll start with New York Times versus Sullivan. um, Okay, so New York Times versus Sullivan is one of maybe the most important First Amendment decision of the Supreme Court. Um, the two most important ones that we talk about in this course are uh, um New York Times versus the United States, Pentagon Papers case, and this one, New York Times versus Sullivan. Does anyone want to present New York Times versus Sullivan? Anybody who's ready, careful enough that they if they could start us out?
I
I've
think
been,
I was gonna say, I think I have a good enough understanding of it.
Okay. Who else was who else was Brianna? Was that you? You were smiling. Oh, okay. Okay, so go ahead. That'd be great.
So the New York Times versus Sullivan, basically, it was Commissioner Sullivan. He was a police commissioner, and he tried to sue the New York Times for basically defamation after there was an ad printed about the mistreatment of African Americans in the southern states, but there was no actual name printed in the ad. And he went to court in Alabama. They gave him, like, they found in favor of him, took it to court again, took it to the Supreme Court. They found that the Alabama law was unjust, and they actually ruled it was unjust for the First Amendment, and they ruled that journalism is allowed to make like mistakes, and for like public figures specifically to get like defamation, they have to pass the malice test, so the person has to like have knowledge of falsification or recklessly disregard for the truth, so he no longer like had a case.
Right. That's a good summary. Uh, does anyone else want to chime in with any other parts of
Is
this case that they
is that the first time? Is that the first time the Supreme Court was unanimous? No, is that the first time that the Supreme Court came out with the actual malice
Yes.
as okay?
Yeah, this is the case where actual malice, where they laid out the actual malice standard. Um, Anyone else have information about New York Times versus Sullivan? There is an attachment to
Is
one
there
of the announcements. I think it's
was
Sage for NYT or NYT Sage. That is an article I wrote on, sort of an academic article that I wrote on this case because of its importance. But was somebody gonna say something? Did I cut him off?
Oh, I was just going to say, other than actual malice, was there any other kind of new test criteria that came out of that, like reckless
Well,
disregard for the truth?
I mean that is the most important thing. That was the ruling of the court, is that public officials, they later then apply this to public figures, but that the public officials, to win a defamation case, um, have to prove actual malice. And what they mean by actual malice is reckless disregard for the truth or knowledge of falsity. Um,
Which is all over the place nowadays.
right. But so reckless disregard for the truth, um, um, that means there has to be more proof than just that the news organization or the author was careless. There has to be the additional proof that they knew what they were writing was false, or that they were just reckless in the way in which they uh, uh, reported the story. So for example, an example of recklessness on behalf of a journalist would be feeling to call up the if you were if the if someone is writing or broadcasting a story about a public official, but they don't get and they've been working on some sort of like investigative report, and they don't get the public officials give the public official a chance to comment and to or to explain to give a different explanation for the facts that the reporter has come up with. That would count as reckless disregard for the truth.
And
Go
this
ahead.
is kind of, oh, I was going to say, this is why you've got like Fox News and the Giuliani and Sydney Dominions just taking everyone to task.
Uh, yeah, except that I mean, you got to sort of like distinguish. Um, I mean, what the Fox News and the Dominion um, and the Dominion case show is that it's still possible to, under the actual malice test, to win a defamation case. This doesn't raise the bar so high that there can't be a judgment. And so, like, the Fox News and Dominion voting, that was an outgrowth of the 2020 election and claims that Dominion voting machines were rigged to to change Trump votes to Biden votes. And and Fox News had reported those claims without doing the kind of checking that they needed to do. There wasn't actually and that ended up with that result. The defamation suit against Fox brought out a lot of internal Fox emails. It allowed there to be court discovery, and brought out emails that showed that a number of the Fox journalists didn't believe, knew that the allegations that they were reporting were false, and that there wasn't any evidence of the election being stolen, and were commenting about that in their emails. So that sort of helped meet this standard of knowledge of falsity, reckless disregard for the truth. And that case ended in a settlement where Fox admitted that they had published the broadcast false information about Dominion voting machines, and it was a settlement where Fox agreed to pay. I think it was something on the order of $700 million to Dominion voting. There are a couple other defamation cases that came out of the 2020 election. A number of them were filed. There were two black poll workers, a mother and daughter in Atlanta, whom Rudy Giuliani, the former mayor of New York City at the time of 9/11, and himself a former associate U.S. Attorney General, that Rudy Giuliani made claims that these two women had stuffed ballot boxes in Atlanta and for Biden, and um, then President Trump, uh, because Giuliani was his lawyer, made the same claims, and in the court cases that followed, the two women suing Giuliani and also suing a online news source in St. Louis called the Gateway Pundit, which had written a lot of stories about them supposedly stuffing the ballot boxes. That resulted in court cases that showed that wasn't true. The January 6th Commission had those women testify and also had evidence that that wasn't true. So Giuliani ended up suffering a very steep defamation judgment against him. And as a matter of fact, the most recent thing I saw in that case was because um, he is going broke. He's having to turn over keys to an apartment and to some expensive cars to begin to pay back that judgment. Um, so those were some notable defamation cases that came out of that show that it's still possible to win large liable judgments in cases involving public figures. Um, I mean, one thing, just to clarify one thing relating to the two poll workers from Georgia is that they, of course, uh, uh, they are not public figures, and when a speaker like Giuliani um, makes claims about private individuals like them, then the actual malice standard doesn't come into play because there's it's easier for a private individual to win a defamation uh, to win a defamation case. Um, so what is defamation?
I think making false claims. I'm not sure though.
Yeah, it's making generally false claims that wreck somebody's reputation. There's different kinds of defamation. Libel is written defamation. Slander is spoken defamation. Uh, Postings on Twitter count as libel. Sometimes people refer to that as twibel. Uh, the
False statements.
um, and the thing about New York Times versus Sullivan is it was a sort of a constitutional revolution in the way these kinds of cases were handled because up until this point, up until 1964, um, all libel cases were governed by state law. Um, and so every state has got, I think every state I know of has defamation laws, and most of the libel cases were ones that were filed in state court. And so for the Supreme Court to come in and say, put a U.S. federal constitutional standard into play that for all libel cases in the United States was a fairly big constitutional revolution. This was occurring at the time of the Warren Court. I think I've mentioned to you a couple of times that the Warren Court, named after Chief Justice Earl Warren, was the most liberal court in the history of the United States. It lasted basically from 1954, when Earl Warren, the Republican governor of California, was made Chief Justice, and in his very first term as Chief Justice, handed down Brown versus Board of Education, desegregating schools, saying that segregated schools in the South and border states were unconstitutional violation of the Equal Protection Clause of the 14th Amendment. So that was the beginning of the Warren Court. And Earl Warren retired as Chief Justice, I believe, in 1968. So 54 to 68 was that period of time. And New York Times versus Sullivan was dead in the center. The other thing to know that you need to know about New York Times versus Sullivan is is the civil rights backdrop, which we were talking about a little bit. So Sullivan was a public safety commissioner in Alabama at the time, and this is the heart of the civil rights movement. This case goes to the Supreme Court in the fall of 1964. So this is right. Um, this is right after Martin Luther King's Poor Persons March on Washington, D.C. in the summer of 1963, and it's before Congress, after the assassination of John F. Kennedy, passed the Civil Rights Act of 1964 in the summer of 1964, the Civil Rights Act ending legal segregation throughout the South. So what motivated the U.S. Supreme Court, and there's sort of a famous line from New York Times versus Sullivan that refers to how democracy needs breathing room for mistakes. What they were concerned about was that Southern segregationist politicians were using state libel laws to try to get big judgments from Southern juries that against the national media, but mostly the national media that had come to the South to cover the civil rights movement. There was Freedom Summer, I think, in the summer of 1963. Poor People's March, a march on Montgomery, Alabama for voting rights, in which some of the marchers were killed. And so this was a period of time that, well, the bombing of the 16th Street Baptist Church, where 4 little girls were killed in Birmingham, Alabama. So this is a time when there is a tremendous amount of news coverage and a lot of TV coverage showing the abuses of Southern sheriffs in trying to quell the civil rights protests. Bull Connor was the sort of the most famous of these sheriffs who used police dogs and fire hoses against mostly teenage demonstrators in Birmingham. And so the pictures of the dogs biting at the demonstrators and the high-powered fire hoses knocking them off their feet. These were going all around the United States and were really resulting in a big shift in American public opinion, and a big shift that then led to Congress passing the Civil Rights Act, which had up to that point been blocked by a filibuster by the Southern senators. Southern senators who were mostly in the Democratic Party. This was before the realignment of the parties over the issue of race. So what the Supreme Court was concerned about was that Southern segregationist politicians were effectively using the defamation laws, the libel laws, to get big judgments against national and media in hopes of getting them out of the South and ending that kind of coverage. This was a $500,000 judgment in this case, which was big. I mean, it's not big by today's standards. It was big by 1960 standards, but it wasn't the only one. New York Times had many other judgments against it in southern courts. And the New York Times wasn't really as strong a publication at that point financially as they are today, for example. And the business side of the New York Times actually asked the news side to get their reporters out of the South because they didn't think that they could withstand um, the financial burden of the libel judgments. CBS had a bunch of judgments against them. Um, and so that's one of the things that motivated the Supreme Court. Martin Luther King was sort of at his height at this period of time. He was actually in the courtroom on the day of the oral argument in New York Times versus Sullivan, and um, one of the justices, he had just written a book about his efforts at desegregation, and one of the justices sent down a copy of the book to get his his autograph on it. So that gives you an idea of the extent to which Martin Luther King was becoming a celebrity. Um, this was just after the famous I Have a Dream speech at that 1963 March on Washington. So that's the context. Sullivan, who, as you know, as you mentioned, was not mentioned. It was important that Sullivan was not mentioned in the case. His name was not. It was not mentioned in the New York Times publication. What was the New York Times publication that Sullivan said had defamed him? Was it a news story?
No, it was like an ad that Abacus had like taken out. They had like paid for it, and it was supposed to look like an actual like story, but it was really like this ad.
Yeah, it was a full page ad, and but it did look like a news story. There was a title on it that said, "Heed their rising voices." In other words, pay attention to what they're saying. And that was a headline that had been taken from a New York Times editorial on the civil rights movement at the time. What were the mistakes that Sullivan pointed to in the ad that he thought had caused uh, justified a defamation judgment? There were a couple little, really, I mean, I think in sort of in the terms that that we look at defamation cases now would be in the realm of careless mistakes. So they didn't rise to the actual malice standard that the Supreme Court was announcing. Uh, One of them was, how many times had Martin Luther King been arrested and put in jail in the South for protests? Um, yeah, it was four, and I think they said seven. Is that something? Um, go go ahead. Aaron, did you have?
Oh, I was just gonna say, yeah, they said it said seven, but it was four.
Right.
And then there
Um,
was some other stuff about student protesters and the treatment of protesters that was um, inaccurate.
right. The protesters were singing. They said they were
Pat,
singing one patriotic song or singing another one. I
padlock in the cafeteria or something.
and that the police had blocked the protesting students from getting to the cafeteria. So sort of the implication that they were sort of starving the students out. Um, so this was signed by some of the most famous uh, black leaders and celebrities in the country. Um, the Southern Leadership Conference on Civil Rights was, and many of the civil rights leaders at the time, like Ralph Abernathy, were ministers, and as was Martin Luther King. So this is all this decision, 1968. This is 4 years before King is assassinated. Um, so those are the mistakes that were in the ad, and the Supreme Court said that's the kind of thing that's the kind of mistake that has to be protected by the First Amendment because it's a careless mistake, and democracy needs breathing room for that kind of error. Let's see, what do you all think about it? Does it protect the press and political speakers or authors? Does it provide too much protection? Is it too hard to, does it make it too hard to win a defamation case?
Excuse me, when I was thinking about it, it reminded me of how lies in a political campaign can be protected under free speech.
Yeah, that's right. I mean, we actually, I don't think read the sort of the most prominent case um, that protected lies in a political campaign. It's one that's actually a case that is on one of the optional essays on the final, and it involves a California water commissioner who claimed he had won the Congressional Medal of Honor. You know, which, I mean, the Congressional Medal of Honor is not just like a Purple Heart or something. I mean, it is the highest honor that can be awarded for valor, and many of it's oftentimes awarded posthumously because the person who did the heroic acts doesn't make it. So this water commissioner who hadn't gotten any kind of medal, I'm not even sure if he'd been in the military. His name was Alvarez. Um, so a huge, he made a huge lie, and he was, I guess he won the election. He was then prosecuted under the stolen valor law, which means you can't lie about your military record. And the Supreme Court threw out his conviction because they said the law was too broadly worded. Congress then came back, and wrote a new stolen valor law that has been upheld since then in the lower courts. That was more narrowly, wasn't so vague. Um, but also, I, um, you know, it, political speech is so often hyperbolic, that, and hyperbole is something that is hyperbole and parody, as we see in the Hustler case, that receives quite a bit of protection from the Supreme Court. I just so like when you get to say the statements that people made in some people made in the 2024 election, like the sort of one that jumps out is that one at the debate about people in Springfield, Ohio, Haitians eating cats and dogs. I mean, that was not true. And but no one no one, you didn't hear any discussion about whether or not there would be a lawsuit brought, a defamation suit brought. No, partly because it would be hard for any particular individual to show that they were harmed. I mean, that's something that's um, defamation is one. You know how last week we talked about news gathering torts. Well, one of them is 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 defamation. It is so you have to prove in court that you were harmed if you're going to collect any kind of damages. And so, yeah, you're absolutely right that um, political speech has a lot of First Amendment protection. Other comments?
I actually have questions about the whole Fox News defamation case that we were
Okay,
talking about
shoot.
earlier. So, like, the first question I had was like, I also read that news that Fox had to pay a fine for reporting false information, but like after I read more about the First Amendment, like I don't remember which case it was, but it was decided that, you know, whenever a news organization defames someone, the government pays for that, not the news organization. So I was confused about that thing. And the second thing I was confused about was that the words that they said caused a disturbance, right? So why weren't they like put in jail or something for that? Because, like, you know, in earlier cases, people were put on jail or something like that, or given a fine, but those people just got off scot-free.
Uh, well, I'm not sure why you think that uh, why you think the government pays in a case like that Dominion voting. I mean, Fox News had to pay. And Giuliani has to pay. It's not the government in a case like this who ends up having to pay. And when you say that there was a disruption, are you meaning in the case of the Georgia poll workers? I mean, they
No, I
ended
just
up.
mean like
Go ahead.
the riot in Capitol Hill, like, you know, Fox News kind of led to that event, right? But like they weren't charged for anything. It's only the people who rioted that were, you know, caught.
Well, so Fox News was the Dominion Voting, who made the voting machines that were claimed to be changing votes from Trump to Biden. Um, so they're the ones who filed the lawsuit against Fox News. Fox News, I mean, you're right in saying that it was Fox News was running allegations by Republican officials. So it's not like it wasn't their own reporters uh, who were saying we found this to be true, but they were broadcasting the claims of Republican lawyers and politicians like Giuliani and Trump about the women stuffing about the Dominion voting machines changing the totals. They were publishing those even though their internal emails showed that they didn't believe them, that they believed the claims to be false and made up. But Fox uh, is a private corporation. It's owned by Rupert Murdoch, a very powerful uh, um, media owner who has holdings all around the world. I think maybe he's originally from Australia, but he has holdings in Australia, Great Britain, and the United States. His holdings include not only Fox but also Wall Street Journal. The Wall Street Journal, though, is a totally different uh, media operation because they have Um, they operate their news on traditional journalistic um, ethics principles. So they try to write straight ahead, fair and balanced news stories. Now, their editorial page has a very strong conservative opinion, but their news organization doesn't just. The Wall Street Journal never published that the 2020 election was stolen. They published to the contrary. They published that all the evidence showed it wasn't. So, but it's a private corporation. So the government, in the Dominion voting versus Fox, there's no government entity involved. Those are two private parties. When the Georgia poll workers sued Rudy Giuliani and the Gateway Pundit, everybody in that is also private. Giuliani was the private lawyer representing the president. He wasn't on the White House staff or anything. And the poll workers, I mean, they had been carrying out official duties that were claimed to be claimed to be stuffing the ballot boxes. But they sued for the damage that the false allegations did to their private lives. They ended up being the victims of, they had to move out of their house. They were the victims of all sorts of online and harassment and personal harassment in their neighborhood. So, I mean, if you look at the defamation cases that came out of the 2020 election, they were pretty important in sort of being a forum in which these allegations could be tested, and in providing a redress, award of money, large award of money to the people who were falsely accused of having rigged the election. Does that help, officer?
Yeah, thank you for clarifying.
Okay. Other comments?
I have a case related to it that's recent.
Okay, great.
Amanda Jones is that librarian. She actually tried suing some people who were falsely claiming that she was giving pornography to children. And at first, I think, if I'm remembering right, they denied that she was a public figure. But then she later ended up winning the fact that she was a public figure, especially considering that she was getting more famous as the issues kept coming along. And in the first appellant, they found that she could prove defamatory words three ways: that the defendant's statements are not mere statements of opinion, but assert objected facts that were provably false. The evidence is defendants knew their statements were false and maliciously intended to confuse or, at minimum, recklessly disregard the truth. And Jones's verified petition is sufficient to establish injury, because injury was not just monetary or physical. So she demonstrated a probability of success in proving each element of her defamation claim, though she later lost one of her appeals. I'll go ahead and link in the chat the first case in which all of that happened. And
where did this happen?
in Louisiana.
Louisiana, okay.
In fact, she has a website of all of the updates for her court cases. So I'll link that too. But she's still ongoing, trying to appeal and win her defamation suit, because these were two people who were not even in her parish who came and listen to the public meeting at her local library. She's a school librarian, not a public librarian, but she came to the public librarian meeting to basically have her colleagues back in the public library. And these two who started the defamation aren't even from the area. And they started taking to Facebook and Twitter and all these social media sites and making memes and calling her, a groomer and advocating for anal sex in schools for 11-year-olds and all of that. So it's ongoing, but I figured it's recent and it was similar to these defamation suits. So I just wanted to
Right.
bring it up.
No, that's a good one. That's interesting. I guess I didn't know about that. I don't know if I wonder if there are other suits where librarians were falsely accused of grooming and that sort of thing where they were able to win in court.
There have been several. Unfortunately, none of them have been able to be as successful as Amanda because they haven't been able to prove that they're a public figure in their courts.
Well, so here's the problem I have with that statement. So proving that she's a public figure, that should make it harder for her to win a defamation case, just like it was, Sullivan was a public official who was who was accused of doing things and claimed that the accusations had mistakes and so that he was falsely accused. So it seems to me that she would have an easier time winning as a private individual. Did you read enough of that to be able to respond to that? I mean, I haven't read the case, so I don't.
Yeah, I read her memoir about it, but it was a while ago, and I
Uh,
can't quite remember the beginnings of it. But
well, it's interesting.
I'll
I'm glad it's interesting. I'm glad you brought it in.
yeah, I'll look more into it.
Yeah, that would be great. Um, I mean, it reminds me a little bit of the case that we were talking about earlier in the class, the Milkovich case um, in Ohio. Did any of you read that one? So Milkovich was um, Milkovich was a famous,
The wrestler.
yeah, wrestling coach, famous wrestling coach in Ohio. His teams had been very successful and winning state championships and stuff. And at one of the local wrestling meets, there was a fight broke out, and the state sports public school sports authorities were investigating it. And Milkovich testified before that inquiry, and basically said he and his coaches from, I think their high school is like Maple High School, that they had not done anything to um, to cause the outbreak of the riot. And a sports reporter for a local newspaper, I think it was Lorraine Publishing Company, uh, said that anyone who had been at the wrestling meet and had heard Milkovich testify knew that he wasn't telling the truth. And so Milkovich sued the sports reporter, and it went to the U.S. Supreme Court, and Milkovich won. And here's the issue involved. After New York Times versus Sullivan, there were a number of cases where the Supreme Court had said, sort of in passing, that opinion would not ever be the source of defamation. There's only factual statements that you could sue on. And in Milkovich, Chief Justice Rehnquist said, yeah, we said that, but that was never the holding of the case. So this is he said it was just something that lawyers refer to as dicta. You know, a passage, dicta is a passage from a case that isn't the that isn't the legal ruling that the case stands for. And so he said, we said it, but we didn't say it when we're explaining the holding of our case in New York Times versus Sullivan. And that, in fact, some kinds of opinion can be the subject of a defamation suit. And the kind of opinion that is subject to a defamation suit is one that is an opinion that is linked to certain claimed facts. And so in this case, that the wrestling coach had been involved in the riot and had lied about it. Those are either he did or he didn't. Those are facts. And so whether or not those are true facts was relevant to the defamation case. Well, this caused a little bit of panic at lots of newspapers because they had sort of taken the dicta. Media lawyers had thought the Supreme Court's dicta about opinion not being subject to defamation pretty literally, and thought that in general, most opinion pieces that news organizations published wouldn't end up getting them in trouble. Well, suddenly it looked as though it might. As things have played out in the decades since Milkovich, the alarm of news of media lawyers about opinion being covered as well really hasn't borne out. That hasn't been the source of that much that much defamation. Is there someone who would like to explain Hustler v. Falwell?
Real quickly, I did find more about that case.
Oh, go ahead.
Yeah. Apparently the judge initially threw it out because she didn't consider the statements to be defamatory because of the opinion. And she said that it didn't matter if she had filed as a public or a private citizen because of that.
Oh, okay. Yeah, that's good additional information. Anybody want to lay out Hustler v. Falwell?
Yeah, I'll do it.
Okay, you go for it, Aaron.
This was the parody or satire. Does the First Amendment protect that, even if it's offensive and outrageous to some people? Hustler did some satire on Reverend Jerry Falwell, who's a televangelist and was quite famous. Probably still is quite famous. I don't think Falwell's with us anymore.
Yeah, he's not. His son is, and his son is pretty famous too, Jerry Falwell Jr.
It was a fake ad, and did have a disclaimer, I think, that said like parody not to be taken seriously or something like that.
Very small print at the bottom. Yeah, go ahead.
It's there.
Yeah.
The jury rejected Falwell's libel claim. The Supreme Court ruled or unanimously reversed it.
Well, vice versa. The jury was sympathetic to Falwell and gave him I think it was like a $500,000.
He won the $150,000.
150,000. Okay, great.
Yeah. And then he won the $150,000. And then the Supreme Court reversed it. I think that one was unanimous too. Public figures cannot recover damages for emotional distress caused by a parody or satire unless it includes a false statement and or actual malice as well.
So this was, yeah, go ahead.
No,
Okay. Okay, that's great. So yes, Jerry
basically,
Falwell, go ahead. Go ahead,
I
Aaron.
just satire and parody. In the writing of the satire and parody is protected forms of free speech. Rehnquist, right?
Yeah, right. Now this decision, well, I mean, it's a Falwell was, as you say, was famous across the country. He was he had been the leader of um, he had been uh, the sort of leader of a whole wave of evangelical ministers who were supportive of Ronald Reagan back in that period of time. They were referred to, those ministers and their followers were referred to as the moral majority. And they were very motivated by topics like Roe versus Wade and abortion, and they had the Falwell's moral majority was considered to be a um, very influential in helping Ronald Reagan get elected in 1980, and then in 1982 there was an election, well, it's a lot like the one we just experienced, where there were quite a number of, well, where the U.S. Senate switched from being Democrat to Republican, and the moral majority's involvement in that was thought to be very important. Um, um, so he was famous. Larry Flint was sort of famous, for publishing this um, pornographic magazine, Hustler. There eventually was uh, I mean, he was a pretty crude individual, and there was eventually a movie made on this as a sidelight. The judge in the movie was played by Justice Harry Blackmun, who was the author of Roe versus Wade. Um, and The other thing I found that was interesting in this case is that I was at a First Amendment meeting, lawyers meeting about 10 years ago, and I sat next to a woman who had written the amicus brief, the friend of the court brief that was filed on behalf of Larry Flint by America's sort of newspaper and magazine cartoonists. And this lawyer told me that she had found out in putting together that brief that Rehnquist was, when he was at Stanford Law School, really loved to, I mean, his avocation was political cartooning. He just loved the political cartoons of the 19th century, the Boston. You probably have seen some of those, and um, uh, that depicted the democratic city machine of Boss Tweed that was very corrupt. So Rehnquist really loved all this, and so they knew um, that this was a way in which they could appeal to him to give more First Amendment protection to political cartooning. And you'll see in his opinion that he says that he cites some of the political cartoons of the of that of the 19th century, and says that the Hustler parody is a um, a poor cousin, I think he says, to those. But still, still deserves protection by the First Amendment. The other
It's
reason,
interesting.
go ahead.
I just thought of it, but it's interesting if you watch any of those late night shows, um, some of them will they'll be pretty serious about stating that it's satire and parody just while they're doing the skit,
Right. Yeah.
especially if it's like politics or if, if they're doing who's the My Pillow guy who's a
Oh,
uh,
I
out
know
of
who you
control
mean.
crazy
Yeah.
person. Yeah, they'll parody him and they'll be pretty serious about say you'll always hear mention or usually hear mention of parody and satire.
Well, I mean, it is the Hustler case. If any of those late night comedians get sued for defamation, it would be the Hustler case that they would be relying on to defend themselves. So that's a good, same thing with Saturday Night Live. Um, the fact that Rehnquist wrote this decision was very significant, and here's why. Um, Even though New York Times versus Sullivan had been, I believe it was a unanimous court, there was a lot of the justices who weren't really sold on nationalizing defamation. And there were a lot of the justices, even Brennan, who at the time were not big fans of uh, some of the national reporting that was going on, partly because some of the national reporting that occurred after New York Times versus Sullivan involved justices of the Supreme Court. It was reporting about Abe Fortas, um, a justice of the Supreme Court, that led to Fortas being forced off the court and to the demise of Fortas being nominated by Lyndon Johnson to be the successor to Earl Warren. So, and Fortas had been a very sharp liberal justice. He was a New York lawyer. That he was what forced him off the court was he had taken a legal retainer from from a party that appeared before the Supreme Court at some point or another, and he had to resign, and so there was some feeling amongst the justices that New York Times versus Sullivan maybe opened the door too wide. Also, Rehnquist, uh, so Rehnquist joined the court, was appointed by Nixon right around this time. So, I mean, the sequence of events was stories appear about Fortas having this arrangement. He's forced to withdraw as the Chief Justice, the nominee to be Chief Justice of the Supreme Court. And then Nixon, a few months later, appoints Rehnquist, not as Chief Justice, but appoints Rehnquist to the court. And Rehnquist Rehnquist was a very conservative justice. Um, and he and so he was a pretty reliable um, uh, conservative vote on the Supreme Court, and he had written in some of his cases, some of his decisions that he had some of his writings were not at all supportive of New York Times versus Sullivan. So when he comes out and uses New York Times versus Sullivan to decide the Hustler v. Falwell case on behalf of political cartoonists, this was like, I mean, it was an important signal that New York Times versus Sullivan was safe from some of these reconsiderations that some of the justices had been sort of privately saying on the court. It's not entirely out of the woods. Chief Justice Thomas and Justice Alito have, oh no, Justice Thomas and I believe it's Justice Gorsuch, to the conservative justices on the current court have called for revisiting New York Times versus Sullivan. Trump in his 2016 election campaign spoke a lot about how he thought it was too hard to win, too hard to win win liable cases, and that he was going to change all that. But because this is a constitutional decision, it's not like the Congress can write a law that makes it harder for public officials uh, uh, to lose that benefits public officials in liable cases, because the Constitution trumps any kind of law that Congress might pass. Any any questions?
I just wanted to say that, like we were talking about that late night comedians. Like, I was watching comedies. I don't remember. I think it was Comedy Central or something. I don't remember. So, like, apparently Trump said that he will hold the comedians responsible if they, make fun of him, something like that. And the comedian was like, "Hey, dude, it's already hard coming here at midnight and cracking jokes." So like why are you, coming after us?
Yeah, I mean, I don't, and to be honest with you, I mean, to be um, President Trump as a candidate, and his comments during some campaign events, particularly in 2016, um, he ended up being protected by this whole kind of protection for hyperbole. Um, so you may remember in 2016 there was a campaign event where some protesters were present, and some people in the audience started beating him up, and Trump made some comments that were interpreted by some people as encouraging them to go ahead and take care of them. And there was a there was a lawsuit that resulted from that, and I believe, although I'm citing an old memory here, uh, I believe that the judge pointed out that this was political hyperbole. And so Trump himself has been protected by the hyperbolic, the greater protection that the Supreme Court's opinions provide for hyperbole, political speech, parody, um, exaggeration of various sorts.
Although I will say that the Hustler magazine went a bit too far. Would you agree? Like
Yeah.
parody is okay, but it went too far.
Well, this was a really gross parody. I mean, the Aaron spared us the details, but I mean, it said that the Jerry Falwell had his first time, meaning his first time having sex, was with his mother in an outhouse. Well, I mean, that was clearly false. I mean, and that's one criticism I've heard of the Hustler Review magazine opinion of Rehnquist, is that okay, even if you say New York Times versus Sullivan applies, it was clearly false and published with knowledge of falsity. All parody is published with knowledge of falsity. So how do you apply the actual malice standard? Um, a couple of the comments that people have made point out that it makes a difference whether a person suing is who feels as though they have been the victim of defamation. It makes a difference whether they are a public figure or a private individual. New York Times versus Sullivan just related to public officials. Later, there were additional decisions that extended that to public figures, but it's never entirely clear who is a public official and who is a public figure and who are private individuals. As the case that we're talking about the librarian. So it's easier for a private individual who feels they have been defamed to win. They don't have to prove actual malice. The public official or a public figure does have to prove. So this is always a preliminary issue that gets litigated in each case. Are we talking about a private individual or a public figure or public figure or public official? It's also complicated because sometimes the Supreme Court's lines don't entirely make sense. Like, a police officer is a public official slash figure covered by New York Times versus Sullivan. So they have a harder time proving they have to prove actual malice. But a firefighter isn't. And the way the Supreme Court draws that distinction is the police officer carries a gun and can exercise deadly force. Another another example of there was a Firestone heir to a Firestone tire fortune. You guys, I don't even know. Are there Firestone tires anymore? This was Firestone was one of the really big manufacturers, and the heir to the fortune was a young woman who, and the story involved adultery in her marriage, and the Supreme Court said she was not a public figure, even though she was one of the wealthiest people in the United States. So that is a sort of a difficult issue in a lot of these cases. I think we pretty much have covered libel. And other kinds of defamation. Trying to think ahead to the test.
Did we cover Tinker? Did we cover Tinker?
No, that's next.
Okay.
Public speech in public schools. Would you like to? Tinker would be a nice place to go from where we are. Who was that who said that about Tinker? You want to do Tinker? I can't hear you.
Sorry. It was basically how they ruled that the First Amendment doesn't stop at the schoolhouse gate, and that
Yes.
students have free First Amendment rights as well, free speech rights, and that, but Hazelwood Kohlmeyer ruled that a principal can censor a student newspaper, though.
I mean, in a nutshell, that's absolutely those are the main things you need to take away from those two cases. So who was Mary Beth Tinker?
What's that?
Who was she, Mary Beth Tinker? What was she doing? What was her speech?
They were a group of students decided to wear black armbands to protest the Vietnam War.
Mhm.
And then the school district found out that they were going to do that, and then pretty much like immediately adopted a policy that banned wearing armbands. And then the students did it anyways, and then they were suspended. Um, and basically the court ruled that the students' free speech was violated, and as long as they're not being like disruptive or anything to the school environment, then that speech is protected at school.
Yeah, good. Yeah, so she's a little girl, black armband, protesting the Vietnam War. Again, sort of like with New York, time-wise, with New York Times versus Sullivan, this is back at the time of the war in court. And I mean, actually, in some ways, it was a bridge too far for some of the older justices on the court. I believe that one of the dissenters was Justice Black. You may remember that when we talked about Justice Black's opinion in the Pentagon Papers, Justice Black's opinion was the one that said, he's the absolutist on the First Amendment. No law means no law. Um, um, but when it came to little Mary Beth Tinker and her anti-war protest in against the Vietnam War, the then, I don't know, he was an octogenarian by that point. He didn't think no law applied in this case. He thought that public school officials needed to be able to enforce um, um, rules. Um, Black, just as an aside, Black has sort of an interesting background. He had been a U.S. Senator from Alabama, and his nomination by Franklin Roosevelt to the court was sort of controversial, partly because he had at one point been in the Ku Klux Klan. But he surmounted that and got confirmed and was one of the most liberal justices on the court, but not in this one. The majority opinion in Tinker versus Des Moines was written by Abe Fortas, the guy I was just talking about. He was just just about getting himself in trouble, the kind of trouble that's going to force him off the court. So, and then let's move on to Hazelwood versus Kohlmeyer. So Kathy Kohlmeyer was the editor of the student newspaper at Hazelwood High School. It might have been Hazelwood North or Hazelwood East. This is a suburb of St. Louis. This is a case that's sort of near and dear to my heart because I was covering the Supreme Court at the time of this case, and so I actually was present during the oral argument. But this one comes out against the student speech. So what did I think I have in the syllabus, you should take a look at some point. There's a 2-page, what was involved in Hazelwood versus Kohlmeyer was a 2-page spread in the student newspaper, and it was about controversial issues like where could girls get family planning information. How did divorce affect families? How did becoming pregnant while you were in high school affect you and your family? So very controversial subjects. It was the last newspaper of the school year, and the principal sees this paper ready to go out, and he immediately is thinking, my phone is going to light up on Monday morning when the parents of these kids are going to see this and they're going to be up in arms. And so he takes, without talking to the students, to Kathy Kohlmeyer or the other students, he takes this 2-page spread out of the newspaper. I can tell you because I have judged a lot of high school and college and professional journalism contests, I can tell you that this was the kind of work that was extraordinary by student journalists. And I mean, it almost certainly would have won a prize. Maybe it did even win a prize. I don't know. So it was actually terrific work. And what the principal didn't know is that the students hadn't used the names of the students or the parents involved in divorce or something. They had used pseudonyms. Now maybe the readers in in a community could have figured out who the people were. Certainly, everybody would know which young women were pregnant. They would be able to figure that kind of thing out. The key thing to understand about, well, there are several important things to understand about Kuhlmeyer as opposed to Mary Beth Tinker. I mean, part of what is different is about 10 years or more has passed since a more conservative court. That's one thing. Another thing, the difference. It's important to realize that even though the student speech wins in one and loses in the other, that Hazelwood versus Kuhlmeyer does not overturn Tinker versus Des Moines. It differentiates the facts of the case, of the two cases. And this is the way the Supreme Court usually works. If they think a new set of facts requires some sort of modification of where the court seemed to be in another case, they will say how the new case is different. They'll differentiate the case, but they won't overturn the precedent. You know, and like in Roe versus Wade and the Dobbs decision on abortion, they very explicitly overruled the precedent. The current Supreme Court has overruled past precedents more often than most Supreme Courts in the past. To use another example, Brown versus Board of Education, that 1954 decision that Chief Justice Earl Warren issued ending segregated schools. That very specifically overturned an 1896 decision that had said that segregated laws were constitutional even though the 14th Amendment had the equal protection clause. That 1896 decision was called Plessy versus Ferguson. So sometimes, particularly in really important decisions, the Supreme Court will explicitly overrule a previous case. But usually, if they're going to make some change in direction, they'll just find a way to distinguish the new case from the old case, and that's what they did here. And the distinction that they made was that Mary Beth Tinker's armband was student speech. It was her speech. Whereas the publication of the newspaper at Hazelwood, it was called the Spectrum, I think, that was school speech. And so they said where it's school-sponsored speech of any kind, that the principal can weigh in and, edit the newspapers, censor the speech. So this applies not just to student newspapers, it also applies to any school-sponsored activity. Like if there was a cheerleading squad that had some sort of controversial skit, or if the choice of the school play was controversial, and the principal decided it was too racy or too controversial to produce, that he or she could tell the drama club not to do it, because the drama club is a school-sponsored activity. Also, I want to point out that the opinion is written by Justice White, Byron White. I've mentioned White to you before. White was the author of, does anybody remember any of the other cases White wrote that involved the press? He wrote Brandsburg versus Hayes, the confidential source a decision where he found that the First Amendment doesn't protect reporters' confidential sources. And he also wrote a case we didn't read, but I think I have mentioned to you all, which is Zerker versus Stanford Daily. And that's the one where the Supreme Court said that police officials could get a search warrant and search newspaper offices and dark rooms for photos and notes and other kinds of evidence that related to a crime. That one was and Stanford Daily and Zerker was during the Vietnam protests of 1971. Know this because it was right after I was editor of the Stanford Daily, and protesters had broken a big plate glass window and injured police officers who had been called to the scene. And so the Palo Alto Police and Santa Clara County Sheriff's deputies got a search warrant to search for photos that would help them prosecute the protesters who injured the police. And after the decision in Stanford Daily versus Zerker, Congress overturned that decision by passing the Privacy Protection Act, which said law enforcement officials cannot, even with a search warrant, go into newspaper or media offices to get confidential or to get photos or outtakes or notes. They can subpoena them, but they can't come in with a search warrant and just search. And that may, and search warrant versus subpoena, that might not sound like a big difference, but it's a huge difference. Because a subpoena gives when records are subpoenaed, then the party from whom they're subpoenaed, in this case the journalists, get a chance to go to court and say, hey, judge, here's why you shouldn't enforce this subpoena. Whereas in the case of news organizations like the Stanford Daily, the police just came in and just started looking through all the files. They didn't need any kind. There was no chance to present the case in court. Now you might ask yourself, okay, so I just said about a few minutes ago, Congress can't pass a law that overturns New York Times versus Sullivan because that's a constitutional decision. Well, Stanford Daily versus Zerker was a constitutional decision too. So why is it that Congress could overturn that with the Privacy Protection Act? And the reason is this: the First Amendment is the floor below which citizens' rights cannot go. But Congress cannot take away rights that the Supreme Court has granted in its interpretation of the First Amendment. But Congress can add to those rights. They added to the rights and they would add, if Congress passed a federal shield law protecting confidential sources, like a lot of states have, that would be adding to individuals' rights. The Privacy Protection Act added to individuals' rights. So Congress can build on the Supreme Court's this constitutional decisions on the First Amendment, but they can't chip down on those rights that were recognized. I don't think I have a question on that, but I know students oftentimes wonder about it. I believe so it's interesting that I believe both Mary Beth Tinker and Kathy Kuhlmeyer are still sort of, these many years later, I guess it's like 4 decades later for Kathy Kuhlmeyer and and about 5 or 6 decades later for um, Mary Beth Tinker, they still tour the country sort of talking about their cases. Yeah, as a matter of fact, I saw that I'm in Philadelphia babysitting for my grandchildren, and I saw that Kathy Kohlmeyer was going to be speaking at some sort of convention here. I really should have gone to see. I should have gone to see her and not talk to you guys, but I didn't. Uh, I don't know if it was today or not. But it was this week. Um, any questions on those on Tinker versus Des Moines or Kohlmeyer or the Hazelwood case? I mean, I think the Hazelwood case is a terrible decision. That's my personal opinion. Um, and I'm not the only First Amendment lawyer who thinks that. Um, um, and quite a few state legislatures have moved have overturned it in their states by passing laws that provide students with greater protection, greater First Amendment protection, student journalists with greater First Amendment protection. That is true in Illinois. Illinois has passed 2 laws, one involving K through 12. I mean, not K. We don't have any kindergarten journalists, but one involving high school news organizations and one involving college organizations, and that say that administrators and teachers cannot tell the news organization what to write. I mean, they can they can say, "Hey, you got to spell the words right," uh, but they cannot make a substantive decision about what can and can't be published. And those are important protections. There are about 12 to 15 states that have laws that provide those additional protections. Missouri does not have one. But it's, I can tell you as a former director of the School of Journalism at SIU that it's very powerful protection for the journalists. And because there are often administrators don't like what's in the Daily Egyptian, for example, and they'll put some pressure on the administrators in the School of Journalism to do something about it. We had a photo. Stop me if I've told the story to your class. I think I told it to another law class I have. We had a photo in the Daily Egyptian that showed a service, a funeral service for a former chancellor who died at SIU a few years ago, about 5 or 6 years ago. And the photo showed one of the chancellor's granddaughters speaking, who was present at a community memorial service and had spoken at the memorial service. And it was a very sweet picture of her. It was a public memorial service. She was a speaker at it, although she was rather young, like, I don't know, 10 maybe. And as we said, when we were talking about privacy, there are different rules for, when you're dealing with children younger than 18, you are dealing, the legal rules are different. But long story short, the chancellor's widow objected and got pressure put on the then director of the School of Journalism, and to take that photo out of our archives. The widow was very upset that there had been that the Daily Egyptian had a bunch of investigative stories about him hiring his son-in-law and kind of a nepotism kind of case, and also about him possibly having misrepresented his background at a Canadian university before coming to SIU. But at any rate, the fact that the state law protected the journalists was a powerful argument that the director of the School of Journalism should not take any action against the Daily Egyptian. There were before those laws were in effect. We sort of, that's when I was the director of the School of Journalism. We had sort of a workaround, and that was one of the things that White said in this opinion was that student papers are not forums for everyone to put their views in. And so for that reason, I mean, there's a whole area of First Amendment law on public forums. And so if something is declared to be a public forum, there's a more First Amendment protection for that situation. Like say a protest in a park. A park is a public park is a public forum. So, White said student newspapers are not public fora. So public forum law doesn't apply. Well, so a lot of newspapers, including ours, declared the Daily Egyptian to be a public forum, and so that extended the rights of the student journalists, even without a law being passed by Illinois. The other way in which students sometimes were able to publish newspapers that were to keep them from being censored by administrators was an underground paper published, put together and published and distributed off campus. The school administrator doesn't have the power to control that. Any questions so far?
I was just thinking about the internet, since you were talking about just publishing news off campus. Like these days people could post news anonymously and they won't even get caught because the internet, like if they put a fake name on their internet profile, like their school won't be able to catch them.
Yeah, that's right. I mean, I guess an administrator could maybe track down who was the source. I don't know if they would be able to get the administrator would be able to. I guess the administrator would have trouble getting the name of the person behind the name of a person behind an anonymous posting on the internet. But I'm sure that law enforcement officials, if there's an anonymous posting on the internet of, say, some sort of possible school shooting or some sort of illegal activity at a school, I'm sure law enforcement officials could get that. I don't know that an administrator could. But the fact that you bring up it up is that the most recent decision of the Supreme Court actually involved internet speech and internet speech off campus, and that was the speech of a cheerleader who there was a cheerleader who 14-year-old Brandy Levy failed to win a promotion from a junior varsity to varsity cheerleading squad in a Pennsylvania school. She
Yeah, I
said,
read that.
yeah. Do you want to tell us more about it?
Yeah, you sent the news story. I remember she
Right.
basically wasn't appointed for, I don't know, position in the
Yeah.
cheerleading squad, and then she like uh wrote wrote the F word on Snapchat like while she was cussing out her school, and the school basically suspended her. So she went to court and argued that, you know, she had every right to criticize the school, and the court said that it's like the school has authority to do something about student speech when children are in the school, but if when they're out, their parents are responsible for that. So like in that way, and then they said that, but like cyberbullying is still not accepted, and if someone does that even out of school bounds, then they're you know, responsible for it. So in a way, it was a win-win for both sides, for the students that they could, you know, like cuss out their school even when they're not in school, and it was a win for the school as well. Like they could protect, you know, cyberbullying and any other similar thing that people might do when they're out of school.
Right. I mean, I guess I would describe this as mostly a win, sort of a free speech win. Uh, I think I do have this. Nina Totenberg did a good story on this. I think it's on the syllabus, but I'll put it in the chat. Just, oh, I haven't been looking at the chat. All sorts of chat here. Okay. Yeah, so this girl, 14-year-old girl, Brandy Levy, and this is a case that's quite recent. It was 2021. Um, she wrote online when she didn't get promoted to the varsity cheerleading squad. She wrote F the school, F cheer, F everything. And that was along with a photo of herself and a friend flipping the bird to the camera. Um, I think she.
But wouldn't that be a violation of her First Amendment? You know, although she's expressing free speech or whatever, um, you know, it didn't incite any kind of riot or any kind of violence or anything. So why would that, you know, why would they sit there and punish her for that?
Well,
Although it was inappropriate, but you know.
yeah. Well, if she had been in, so this is speech off campus, and if she had, if she were in a classroom and said that to
Then I could see
the history
right?
teacher, she'd get sent to the principal and probably get suspended from school, right?
Correct.
So the 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 school is trying to sort of enforce its rules of decorum and what is protected speech and what isn't, but doing it off campus. It's what the Justice Breyer, who's no longer in the court, wrote that while public schools may have a special interest in regulating some off-campus speech, like the kind of cyberbullying that Hofstra was referring to, but he went on to say that that Levy's speech is the kind of pure speech to which, were she an adult, the First Amendment would provide strong protection. And then Breyer cited back to the um, Mary Beth Tinker case, 1969 case involving armbands, um, and said that the First Amendment protected her speech, Brandy Levy's speech, which was the story has a number of people saying that it was a big victory for the First Amendment. But as Hofstra says, the lawyer for the Pennsylvania School District, which is the Mahoney area school district, said that schools could operate under the rules the Supreme Court set down. because schools can, the Supreme Court said schools can regulate speech, off-campus speech by a student if, there are like consequences
It's,
for inside the school. Go ahead.
yeah, I was reading on there, and it says that it was a 8-1 vote declaring that it was, punishable off campus if it disrupt the classroom, right? So if you ever look at any social media post, whether it's Instagram or whatever, you'll get a whole bunch of trolls in there that'll say all kinds of things. It's up to you to whether you want to read it or not. It's up to the reader whether they're offended or not. So um, it wasn't done directly in the classroom. She was just expressing her feelings at the time. So how is that a disruption in the classroom? For classroom study.
And that's what I think the
That's the
Supreme
gray
Court
area.
was
Go ahead.
basically deciding here, is that this didn't cause a disruption in the classroom. I mean, I guess the school could have argued, and maybe they did argue that, well, how can we run a cheerleading squad if the decisions on who gets to be on the junior varsity squad and who's on the varsity squad subject the teacher to profanity, that it's going to it disrupts the functioning of the cheerleading squad. I mean, that's the argument. That's the kind of, no, you're smiling, and I agree. I'm just trying to make the best possible argument that they could have made. I don't buy it either. Okay.
Definitely not.
I just wanted to share a case that happened in my school that was very similar.
Uh-huh.
Can I?
You
So
may.
like, so when I was like in the 11th grade, like there was this teacher who like when he joked, like he became very rude to his students. So like what happened was apparently he talked very rudely to two of my classmates, and what they did was they sent those screenshots to like a third Facebook page, and that Facebook page basically like posted those screenshot and said, look how this teacher is very rude to his students. And like what happened after that was, interestingly, the school didn't do anything to the students. It directly went after the teacher and were like, you shouldn't have talked to the students like that. And as far as I remember, he was like not allowed to come to the school for some time. But I don't know, somehow he won his case and got back to school. So that was one case that happened in my country.
So that was, where did that happen?
It was my country, Pakistan. It happened
Oh, okay.
like I basically studied at a private school, so I'm not sure if this happens in America or not. But back in my country, private schools, like they value the students more than the teachers. So if a student complains about a teacher, they will definitely listen to them.
Yeah. Yeah, well, hopefully students in the United States have got greater free speech rights because of the First Amendment
Correct. It's
than
supposed to be
Pakistan.
protected, correct?
Huh?
Because free speech is supposed to be protected under the First Amendment, and then when it do
Yeah.
something like that, it's like, come on, are we protected by the First Amendment or not? I don't like the gray areas.
Well,
Unfortunately,
yeah,
like
but
in that cheerleader case, it took years for that to get resolved. So yeah, looking back, whatever several years, it was protected, but in effect, in the moment, um, you're not protected if the school decides to do whatever.
My
well, that's
my my dad always used to say, "You can say anything, you can do anything, just be ready for whatever consequences come next."
yeah, yeah. Well, that's true, and Aaron's also right in saying that all these cases take years to go through the courts. So you're talking about at least you're talking about at least
She's not
3
getting back on the
years
cheer
or
squad that year.
yeah, right, right. Um,
Although I will say I disagree with like people posting stuff like that on the internet. Like if you have a problem, just talk to the teacher directly.
To be
Yeah.
honest, at like my school, you couldn't have. Like, if you went to the teacher directly, you were gonna have more of a problem. Like, you were better off to just vent about it online than you were to deal with it. We had allegations of like sexual assault, we had allegations of rape, we had allegations of just about everything. And what happened was it just got swept under the rug, or like the guy got like a slap on the wrist, got told, "You're not gonna do that again, right?" He went, "Yep, never gonna do that again." He did it like literally the next day, didn't even get suspended or anything. Like, or like people would be like, "This teacher has favorites, this teacher's this." Nothing ever happened, so you were better off to just deal with it on your own.
Uh, yeah, I mean, yes and no, I would say to that
Same.
comment. I mean, I would only, I would, the one way in which I think, Alexis, I would disagree with you is that, I mean, if it's something along the lines of sexual assault or like repeated, like, and I'm talking here about, say, in a public school setting, sexual assault, repeated misogynist, sexist comments. I mean, that's the kind of situation that I mean, that violates the law.
We
And
had like 10 victims come forward. They got the police involved. He was just like, "Oh, I'll never do it again."
was this
And then
a student or a teacher?
it was a student doing it to even younger students. Like he was a high schooler, like a junior doing it to eighth graders.
Uh,
And
and it,
he was just like, "Oh, I'll never do it again." They said, "Oh, you're a good kid." Like 10 people came forward and said he had done it, and they were just like, and so finally, and he was just like, "Oh, I'll never do it again." Didn't even get suspended.
You know, if he was ever convicted, like I've heard about sexual harassment cases before, they usually get like maybe just 2 years, as far as I know.
He never like got in trouble. Nothing. Like nothing is on his record
and
to date.
this was actually sexual assault. He was
Yes,
raping these
he
people.
was touching them. He was sending them inappropriate photos. He was
Yeah, he should have been investigated.
like whole 9 years. They kept the photos too. Like they had evidence of it too. They kept the messages. Like they knew what they were doing.
How long ago was this and where was it?
It was back in like I'm from Murphy, so it was back in then. And it would have been my junior year. He was the same year. He was the same age I am. I'm now 21. It was back when we were 16.
And did you say Murfreesboro?
Mhm. Like he literally just got told, "So you're never going to do that again, right? If
Is
you
this
do that,
was
if you
he,
do." he,
I was just gonna ask, was he like an athlete or
he was a choir boy.
a what?
A choir boy?
A choir boy? You mean like at the church?
No, like we had a choir and he
Oh,
was
okay.
one
Okay, I
and
gotcha.
we were like a top scoring choir and he was part of it.
Oh man. Well,
And they
that's
brought the cops and they were like, "You'll have to deal with them if you ever do it again." And he was like, "I don't know what you're talking about. I didn't do nothing."
well, so oh God, this is such a complicated situation. But I mean, I just think that when you get to like repeated sexual assaults like that, that's not something where you could just can say, um, well, you just got to sort of, it's going to get swept under the rug. You're not going to get anywhere complaining about it anyway.
Oh, it
It,
happened with another dude. We had a whole assembly about him, and then it came out that he had like sexually assaulted several girls.
oh boy.
It was a common thing. So we just, yeah, you just dealt with it online.
I mean, from a legal standpoint, what those girls and the parents and their parents could have done is that they could have filed formal Title IX. Title IX is the protection of against sexual discrimination in education, be it high school or college, and they would have had the right to file a Title IX case against the school district and and to bring in the student as well. And if I'd been advising them, if I'd been one of the parents, that's what I would have done. I mean, proving those,
But most people don't have the money for an attorney, I mean.
yeah, but you know what? There are enough public interest groups that for a situation like that, where there's like a repeated sexual harassment of young girls at a public school. I promise you could get yourself a pro bono lawyer to,
But Professor, I feel the least the school could have done is suspended him or something like that, or maybe
yeah,
just kicked him out.
Like there were at least two common ones. One was like a good chunk older than me, and one was my age. And like everyone knew. Everyone was like, "We avoid those people. We avoid those people." The
yeah.
school knew, and like nothing, nothing.
Well, you can't put it on young females that they've got to avoid somebody, and if they don't avoid somebody, it's their own fault. That argument doesn't fly anymore. That used to be the way people would look at this kind of thing, but yeah, that I really think that has changed, and I'm pretty shocked to hear. I mean, for example, and this is a little bit of a different example, but at the school where I went to high school, and my kids went to high school, Kirkwood High School, there was recently a drama teacher, a former drama teacher who in the 1980s sort of had sex with some of the girls in his productions at Kirkwood High School, and he was forced out, but then he got off over to like a junior college where he taught after that. But just recently, the police filed and reinvestigated, filed charges against him, and he pleaded guilty to rape. Um, and so, I mean, I just cite that as an example of sort of changed approaches that most public schools take towards this kind of thing now, and that it's easier to make a claim of sexual assault than it used to be.
We do
Um,
sexual harassment training here at the library every year, and it's also in education as well. So in the state of Illinois, you can go directly above the administration and go directly to the state to basically just ring the alarm about sexual harassment happening. It doesn't even have to be you who's experiencing it. If you are seeing someone else experiencing it, you can take it directly to the state through like the Department of Human Services or Human Resources, and they will deal with it. And it doesn't cost anything.
and in fact, if you're a person like myself, if I were to witness such a thing in in school, I would have a I would have a responsibility to pass it to do that. I would be not I would have a responsibility to report any kind of thing like that I observed. Did you just put a link in the chat about that? Yeah, okay. Thank you for doing that. Okay, so we're about done here time-wise. Next week we'll finish up a couple of school speech cases, Bong Hits for Jesus um, being the primary one, and then we're going to move on to indecent speech, obscene speech, um, um, the internet, the rules for the internet, section 230 of the communications law, Communications Decency Act, and online speech. So I'll send you as part of my next note on this link, the link to this class. I'll send you, but it's basically the next um, two lessons. And you know what? we're gonna have to also deal next time, if we're gonna not get you guys too far behind, we're gonna also have to go all the way through copyright. So on the syllabus, all the case, we will next week go through all of the cases between where we are, so student speech, and through copyright and review for the test, because I've got the test set up to be available after class next Friday. And don't do it then, we're not gonna have time to finish. We will only have, after next Friday, I believe we only have one class. So anything, read all of the cases between where we are and through copyright, and we will cover all of that next time. Question, Aaron.
Yeah, I had a question on the test. Do you grade the essays in that test, or are those essays that are in that test, are they part of this other kind of do essays for extra credit points?
So the essays that are in any of the tests are, it's voluntary whether you do them. If you do them, let me know you've done them so I can go in and grade them, or just send it or send me your essay as an email, and I'll give you extra credit points. Sometimes depending on what your score is on the main part of the test, sometimes I'll just add them to what your score is on all of the true, false, and matchers. If there's plenty of room to add the essay points in there, if you already have a good score on the rest of the test, then I just give you extra credit points.
Okay, so when you're talking about extra credit essays and like the syllabus and stuff, those are actually already contained within the test.
Yes.
That's not something we need to send you an email on separately or anything.
No, but if on the test you do one of the essays, the extra credit essays, send me an email that says you have, so that I can easily find your
Okay.
essay
I
and
didn't
add
know.
your points. Okay. Yes, sir.
Okay, I was also inquiring about that test as well because I did do the essays on there.
Okay.
And I started a little late, so I know I got to do a little bit of extra, to catch up here. So, do those points roll over? Like, let's just say on the bottom of your grading sheet, you have 200 extra credit points or whatever. Do that kind of rolls over into that to catch up to
Honestly, what I do when I give the final grades is the people who have the highest total points get the best grades. And I'm very forgiving. Almost everybody gets A's and B's. Particularly, those of you who are showing up for most or all of the Zooms. So, but yes, the extra credit points are very valuable. If, for example, you had a 60 out of 100 on a test, but then you had 40 points of extra credit, that basically gets you up to an A. It can take you from a failing grade to an A if you've got those extra credit points. So they're useful to have, particularly if you find yourself lagging. On the test scores. But if I see a student, but on the other hand, if I see a student who has, say, an A on all three tests and doesn't have any extra credit points, they will get an A also, because so it's not it's not I don't want anybody to be penalized if they've done really well on everything, all the content of the course, but they haven't done extra credit stuff. I don't want them to be penalized. Is that clear? Okay.
Professor, I haven't done the test yet, but I'll do it next week. Is that okay?
Okay. Yeah. I mean, the tests all remain up for the rest of the class, but I just don't want you to get I just don't want us to get behind where you don't want to, during finals week, to be taking test 1, test 2, and the final. That'd be a real burden.
Will you,
What's the
Okay.
time?
sorry, will you count me in as president accounted for today, even though I was late and
I
muted?
will. I think
Okay.
I already have, but I'll go back and make sure I did.
Okay, thank you.
And we have like till December 15th, right? To submit everything. I'm just confirming.
You do. And I changed my grades as late as that. Yeah, to the end of finals week. So the second test will be available next week, so you can ruin your Thanksgiving vacation with it. And and then you can ruin your Christmas shopping period of time finishing up finishing up during finals week all what you haven't gotten done.
What's the
This
time
being
difference
a half
between
semester course, we just have to move a little faster. Okay,
what's the time difference between when test 2 opens and when the final week opens?
so the final will open the last day of class. I think, I mean, I'd have to double check to be 100% sure, but I think December, it's either 5th or 6th is our last day of class, and we will cover religion, election law, and review for the final, and the final will be available that day after the class, and then, so you'll have all of finals week to deal with it if you want. Okay. Okay. Glad to see all of you here. I like to have lots of smiling faces. See, and names where I don't have smiling faces. Okay, see you later.
Okay, thanks.
Okay.
Care.
Bye-bye.
Thank you.